Hi, welcome to another episode of Kidon, War Stories on the Cutting Edge of IP Monetization. My name is David L. Cohen. I am the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, and defending intellectual property rights. You can find this show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and more. Today, my guest is Sarah Matheson. For over 25 years, Sarah was a lawyer at Allens, a leading law firm in Australia, specializing in IP protection, commercialization, and litigation in pharmaceuticals, healthcare, engineering, and mining, and telecom. Sarah led the Allens IP Group's healthcare sector team, Innovation Action Group, among many other roles. She also was very involved in pro bono work, including a large number of worthy clients and efforts. Sarah was a member of a number of academic advisory boards for Australian law schools, and among other roles, Reporter General of the International Association for the Protection of Intellectual Property, otherwise known as AIPPI. On the non-legal side, Sarah is the chairman of the board of Australian Ballet School and a member of the board of trustees of the Royal Melbourne Hospital of Neuroscience Foundation, among many other worthy activities. In all these positions, Sarah has earned numerous awards and accolades, including being named the Global Elite Thought Leader for Patents, Lawyer of the Year for Life Sciences, and featured in the Global Top 250 Women in IP. Today, Sarah is no longer a partner in Allens and is focusing on a number of fascinating and fun projects, which I'm sure we'll get to and discuss in due course. So now that I've blown up your head to fit beyond the screen a little bit, maybe why don't we start off at the beginning and briefly, as briefly and as quickly as you like, and of course stories always make it more interesting for our listeners. Describe how you got into IP and in patent litigation in general.
Sure, David. One of the things that I hadn't realised in the time that we've worked together is that with all of those references to David L. Cohen, I'm Sarah L. Matheson. So I think I'm going to adopt that. I think it has a certain gravitas.
Well, there's a very simple reason. Is David Cohen, as I tell people, is like John Smith of Jewish people. So,
right.
So I just add the L, even though it doesn't distinguish me too much. It's just a little distinguishing. But yes, Sarah L. Matheson does have a gravitas.
Yeah, I think I'm going to use that from now on. So back to your question, my original plan was to be a principal dancer with the Australian Ballet Company. And that's what I pretty much put most of my efforts into in my childhood and teens. And I guess little did I then know that a training regime of very early starts, long nights and weekends would set me in very good stead as a litigator, working across lots of different time zones. At the crossroads of the school versus ballet debate, I very reluctantly had to concede that my ambition outweighed my talent, and therefore that it was probably a good idea at this point that school would take precedence. It's one of those things that's slightly embarrassing to admit today, but I really did law because I didn't really quite know what else to do.
Me too.
I thought I would qualify, and a potentially more glamorous career option would eventually reveal itself to me. I trained at a firm that was really excellent if you wanted to be a construction litigator, but this didn't seem to be quite sort of satisfying the creative yearnings that I still had. So I moved and I went to what's now Allens and was immediately buried in mountains of garbage truck patents. That was not really the glamorous new life I had anticipated. But over time, what I realised was that the reason that there was literally an explosion of patent activity in this area was that we were slowly coming to the realisation that we couldn't keep tipping garbage into landfill forever. And so there was this huge uptick in thinking around how we collect recyclables, how we process them, and how we hopefully start to save the planet. And I think that was that was the element that really did satisfy me, because I realised that I was on the right track in that IP, you're always pursuing the new, the clever, and the creative in terms of coming up with solutions to problems. So basically, Allens is where I landed 26 years ago, and where I stayed.
No, so that raises two interesting things. I think you're right. One of the nice things about IP is that the law may or may not change that much in any given career, although I think it has quite a bit in ours. But you're constantly dealing with something new and fascinating. By the nature
Yeah.
of what you have to deal with, it's supposed to be new and fascinating, or at least new. and it does make it exciting and fresh. Although sometimes, I like to say I've met at least 1,000 people who think that they've invented the next best thing since sliced bread, as we say in the States.
Yes, we say that too, and I've probably met a similar number.
Yeah. But you've been in Allen's for you were at Allen's for quite a long time, and the in the U.S. we used to talk about the 25 years or 50 years in a gold watch, and then you were done, and eventually now everyone is their own your own marketing boss, and every 2, 3, 4, 5 years. And at least my observations, I'm going off a little off topic from IP, but it's fascinating that you don't meet too many people nowadays in the States who've been in the same firm. They basically grew up in the same firm and then retired.
Yeah.
Is that unique? Is that common in Australia, or it was common and no longer? I'm just curious if you could speak to that.
Well, certainly when I started legal practice, absolutely, it was common. In fact, in some ways, it was sort of looked on a sort of with a bit of concern if you moved around too much.
Right.
Why did you have to keep moving? And a lot of people, I think, entered their legal career thinking that if they found the firm with the right fit, that's where they would stay. And as you say, that's where they would retire. Certainly over time that has changed dramatically. And if you said that to a young graduate today who was seeking a role in a law firm, they just wouldn't. It just wouldn't be part of their frame of thinking at all. When I was seeking a graduate position in firms, you effectively professed that you had always known that you wanted to be a lawyer from the moment you had conscious thought, and that you imagined that you would be a lawyer for the rest of your life. Having been involved in a lot of graduate recruitment over the years, there's now a much more transparent and open discussion about law being a fantastic career, but certainly not being the only one. And we came to fully expect that people would, some people would stay and build their careers, and we certainly hope that they would do that, but a lot of people would move on and do really interesting things. To the point where sometimes it almost became slightly embarrassing to say that I'd been there for as long as I had.
Right. Well, now I think you're doing some very interesting things, but we'll get to that to foreshadow that. But it's interesting. I'm sure you have a lot of thoughts, or maybe I'll tease some thoughts out of you on the arc of IP development over the past 25 years. But one of the things that I've seen is, and in no small part, I think, to developments that started in Australia with the getting rid of champetry, or whatever they call it nowadays, and litigation funding. But the business of IP is much more business-like and a lens to a lot more creative things than sort of standard commercial litigation. I don't know if you've seen that in Australia as well.
Oh, absolutely. So certainly when I started doing IP, it was a pretty esoteric area, and treated that way by business, and even to be honest, your own law firm. The IP people were always regarded as a bit sort of strange and different, and probably put them up on the top floor, and hopefully we wouldn't have to think about it too much. And I've always done a mix of both transactional commercial IP work and litigation, which tends to be the case for a lot of IP lawyers in Australia because of the size of our market here. And it would be a regular thing that the corporate lawyers would sort of ring you at the 11th hour and say, we're signing the deal tonight. Could you just come down and cast your eye over a few things?
Yeah. A few things being 50 boxes of documents and complicated patents and I recall.
And have we worked out who's actually going to own the name Coca-Cola and similar things like that. So that was very much the way of things, and we prosecuted patents and litigated IP disputes quietly on our own. But I really think there's been such a recognition by business of how fundamental and integrated IP is into commercial life, that we now see it very much embedded, and it would be unthinkable today not to be looking at the IP aspects of a major commercial transaction. And I think that the prominence that certain patent litigation in particular has gained in the public arena means that it's very much part of the mainstream.
No, it's interesting, and it's interesting that you're saying that, because I'm noticing very similar trends, globally, which sort of brings to mind something that when I was a baby lawyer, if you thought about Australia at all, it was a sort of a interesting, odd place, and if you thought about it a little bit more, you say it's very different than here, but they speak English, or at least what they think is English. But it seems to be that there's a lot of convergence, and maybe to situate this for our listener, can you, again, obviously this is a loaded question, but can you give a little, contextualize Australian law and Australian IP law, at least vis-a-vis the most typical common law systems, and maybe a little bit, maybe talk about Germany or European systems, if there is any overlap at all? I mean, I think I know the answer, but you're the expert.
Well, I think, as you said, David, we're essentially with the common law countries. We all draw on the common law, but have codified IP systems that broadly reflect the fact that we're signatories to TRIPS and other key international IP agreements. There are, of course, still substantive differences in the substantive law between the jurisdictions. Just for one example, and here Australia stands with the US. We're still in a minority, in as much as we grant patents for methods of medical treatment per se. That's one difference. For a long time, Australian patent law really tracked very closely to UK patent law, which is not surprising, because that's where our patent system derives from. But as UK patent law started to converge more with European patent law and the civil systems there, we also similarly started to diverge a little from UK IP law. And I think we might say that we sort of remained the common law purists in that regard. But about 10 years ago, we had a very significant overhaul of our IP system. And the stated aim was to better align our IP laws with some of our major trading partners. And that saw the introduction of the Raising the Bar Act, and that was so called particularly in relation to the desire to raise the quality of granted patents in Australia. And the aim was to bring our patentability standards into closer alignment with what we were seeing internationally. And for example, there'd been a sort of a fair divergence from where we set the bar for novelty, for example, versus certainly what was required in European systems. We're not completely, a carbon copy now. There's still quite significant differences in the substantive law. So, for example, we don't have a doctrine of equivalence. Our courts will take a purposive approach to patent claims, looking at how the skilled person would interpret those in light of the specification. But I think also too, and I'm sure you've got comments on this, that differences that might strike foreign litigants are in the context of the actual court procedures and processes. So, taking the US as an example, we don't have juries for patent cases. In fact, the very concept of it strikes fear into the heart of IP litigators here.
I think in the US too, but
well, it's funny. I said you meet US lawyers, and they either seem to think that we've got it right, or they're passionate defenders of the jury system for patents. But our courts tend to be very, very dependent here on on independent expert evidence, and we have
hot tubs.
I can talk to you about hot tubs, but we have really strict rules around briefing experts and taking their evidence, and that's actually what's really driven the development of hot tubs, because our courts were long concerned with experts becoming, even though they were called independent experts, they're retained by the parties. They were too partisan. They were worried that their evidence was tainted by hindsight, and judges were really feeling that they were effectively being, I guess, shielded, if you like, from what the independent expert truly thought.
Right.
So that's that. So does that bring us to hot tubs? Do we want to?
Well, definitely. But before we get to hot tubs, which I love the concept, it scares the lights out of me as a litigant, but I love it as sort of an objective societal benefit for society. But briefly, solicitor barristers, or more like the unified bar?
Yeah, no. So we are still solicitors and barristers, and we still have so that still is the split that you see in the UK, where the solicitor has the main client relationship. They do a lot of, essentially all the pre-trial work with the client, briefing barristers who are the advocacy specialists to actually be on their feet before the judge. That said, we sit behind the barristers and we annoy them endlessly as we set the notes.
Are they like in the UK in really separate ends of court, or they have firms, or can they associate? Can solicitors? Because I know there's a lot of contradictory attempts happening in the UK that I'm not really sure I understand, because I don't follow it in detail, which seems to they want to merge the two practices, but they want to separate them, and then they want to merge them. Do you see that? Can you argue in court at all, for example, as a solicitor? Or
look, I can. There's no actual restriction on me doing so. So once we're admitted to practice, we're actually the actual wording is that you are admitted as a barrister and solicitor of the Supreme Court of whatever state you're in, and so I'm entitled to get on my feet and argue the case in court. But I guess because we've always very much adhered to that English tradition, people tend to either be sort of end up specialising, if you like, either in the preparation and devising the strategy, and then actually arguing the case. Which is not to say that the barristers aren't equally involved in strategy, because I think a really a well-run patent case, for example, involves the barristers early and involves them in developing the strategy, but just really using them strategically for the appearances before the court, because they're much more specialised in the rules of evidence, in terms of their application and the nuances of arguing cases in court. But as I say, we sit behind and we bug them.
Of course. But are they in separate firms, or are they?
Yeah, they're in separate. We don't call them inns of court, but it's a similar concept. They're in separate chambers.
Right.
And so that will just be a large group of barristers who either might or might not have a practice area in common, but they congregate together, and the solicitors congregate together in separate firms.
Cool. Well, so it's sort of like the UK system. It sounds like a little bit with some local tweaks, I guess. So back to hot tubs.
Okay. Okay, back to hot tubs. Okay, so first of all, it's one thing I'd say is that Australians very much tend to adopt anything that's good from New Zealand and effectively claim it as their own. But with hot tubs, that's
very big of you to say that.
We do have to give credit to New Zealand where credit is due. So I think hot tubs actually arose out of New Zealand court practice in antitrust cases. And I'm not entirely sure why it was that they started getting used in Australian patent cases. But that is very much now sort of a standard thing. When you said that hot tubs scare the lights out of you, when judges, and it was sort of judges sitting on patent cases who tended to be a bit more experimental with procedure, and when some of those judges first started indicating that they were very keen on the concept of the hot tub, again, we were all terrified, because I'm not sure whether your listeners are aware, but technically it's called an expert conclave, but the colloquial and somewhat disturbing
It sounds
visual.
almost religious like that.
Yeah, yes, indeed. Yes, so you're either from the sublime to the ridiculous, I guess, with conclave versus hot tub. But in essence, it involves the independent experts on both sides getting together without the lawyers. So you can see why that's why that's terrifying to the lawyers. And it's the practice around that has developed very much over the years. Originally, it was that the court would order that the experts get together without the lawyers, work out which points they agreed and disagreed on, and then prepare a joint report which would be filed before the trial. But increasingly, the judges actually want to hear directly from the experts. They don't want just a written report. And so there'll actually be, in essence, a live hot tub conducted in the course of or immediately prior to the trial, where essentially the experts will sit there in a conversation with the judge. The judge might even let them literally cross-examine each other. And the aim of the exercise is to essentially sort of strip away what judges found extremely boring, which was reading very long affidavits where point scoring and finding something to disagree with at every stage, and to get down to the real issues of difference, because often what many pages of affidavit evidence can boil down to are a few or one key issue, often a matter of interpretation of some aspect of a claim in a patent, on which it might be possible that very intelligent and reasonable minds could differ. And so the judges I really use that hot tub process to really try to hone in on that and effectively get rid of all the noise.
No, I mean, from a societal perspective, I think it's a great thing. As a litigant, I'd be nervous, but I think that's great. But so aside from hot tubs, you have sort of the I guess the benefit of now looking at the arc of your career. What are some of the bigger changes you've seen that I'll pick an arbitrary number. Name two changes that you really think, yeah, that's good that it happened, and two that make you all feel like old fuddy-duddy, all these kids today.
Well, I think in terms of court processes, along with hot tubs, which would really be right up there, I think there's been a very constant, an absolute continuum to try to drive case management procedures in the court. So when I started in practice, parties pretty much set their own timetables and told the judge what it was. You could pretty much rely on getting extensions of time for various procedural steps, and effectively you told the judge when you were ready for trial, and then the judge made some time in their calendar. A lot of that pre-trial work is now very much codified into practice notes, and that arguably leaves less idiosyncratic approaches to that sort of litigation, that pre-trial phase. And by and large, I do think that's a good thing, because it does assist us as advisors to give clients a better idea of what will happen when, how it will happen, what will be required, and therefore obviously to essentially project manage it, which is really what that pre-trial phase is all about. One area that I've seen a lot of, I guess, a lot of waxing and waning is the appetite and the ability to seek an interlocutory injunction in a patent case. And when I say interlocutory injunction, I mean a preliminary injunction, restraining the respondent from doing something that's potentially infringing until the matter's actually gone to trial and the court's finally determined all the issues of infringement and validity. So I think in the UK that's an interim injunction, and a temporary restraining order in the US.
Yep.
So it's always been the case that the quid pro quo for getting an interlocutory or a preliminary injunction was to give the court an undertaking to pay damages if it ultimately turned out that the preliminary injunction was wrongly granted. And along the way, the court decided that it would mandate the form of that undertaking. It was always referred to as the usual undertaking. Do you give, Ms. Matheson, do you give the usual undertaking? Yes, Your Honour, I do, on behalf of my client. The court then prescribed the words for that. And so what that actually meant was then the patentee was required to undertake to the court that they would pay damages to any person affected by the grant of the interlocutory injunction, and that was quite clearly to encompass parties other than those to litigation. So that very much increased the risk associated with seeking an interlocutory injunction. It was mainly in pharmaceutical patents where preliminary injunctions.
Presumably, there could be some life-saving medicine. Someone could die, and that could be a damage.
Yeah, and it was effectively like turning off a tap, because if the patentee has to agree that they'll pay damages to any person affected, bearing in mind that we have a heavily government subsidised system of pharmaceuticals in Australia, and the level of subsidy is very much impacted by patent status, there was grave concerns that the government might actually come after the patentee to seek damages if a generic manufacturer was kept out of the market, while a long-running pharmaceutical patent case was trundling through the courts, ultimately to result in the patent being not infringed or invalid. And in fact, so we used to tell clients that this sort of new form of undertaking had this theoretical possibility. And indeed, in recent years, that has been tested. And you can imagine what sort of the damages figures are that get bandied around.
I'm sure.
You're talking about a lot of money for expensive drugs over potentially some years.
Wow.
So I think that's been a sort of an area of quite a lot of development. And again, you might say, well, that's potentially for the social good, but it's certainly given pause for how patentees run, particularly pharmaceutical patentees, run their cases.
Yeah, so that's fascinating. That's fascinating. And so you focus on litigation. Maybe I asked you on litigation, but I remember when I was back in the day when I was a mid-level associate, I used to work at a firm that did a lot of M&A, and I wanted to do more on the IP side. And one of the partners said to me, "You should enjoy litigation because as bad as it is, at least you have the rules of civil procedure." in deal work, there's no rules. So I'm curious, have you seen any, other than the fact that now it seems like clients are paying more attention, intellectual attention to the IP aspect of their deals, have you seen any major shifts in the past 25 years in IP deals that you've been working on?
Look, I think a key area, a key issue is just the value that's given to IP in the whole deal, recognising that they actually have a really valuable asset, and then actually being very keen, particularly in the due diligence phase, to really understand the IP. Many years ago, I was involved in a global demerger case where I was absolutely informed that the company had no IP. And it was really sort of, what are you even doing here? Are you lawyering up too much on the other side? And I think even the clients sort of thought that having an IP lawyer was a bit of an indulgence. So having been told there was absolutely no IP, I said, well, I'm just looking at these patent searches, and this company that's about to be split up owns literally thousands of patents in pretty much every country I've ever heard of, and ones where I haven't even realised they had patent systems. So if you've got no IP, or you don't think you've got any IP, you've either got a really lazy asset here, eventually you've got something that somebody thinks is of really high value. So I found that increasingly when companies are looking to do deals, much more focus is given to the state of the IP of the company, and not only sort of risks around it, but how it's used, and how intrinsically important it is to how the company does business.
Well, that's I've seen that as well. That's fascinating. So now that you've don't have to face the wrath of an angry judge or something, what do you think are some of the big challenges that the Australian legal system generally, if you want to say that, or if you want to go to the IP in Australia, IP litigation, or just what do you think are some of the interesting challenges that you'd be curious to see how it will be overcome?
Yeah, well, I think I will focus on IP because that's what I've tended to do for such a long time. But I think one of the really big issues that we're still grappling with here, I think it's more settled overseas, is the patentability of computer implemented inventions.
Yes.
Our High Court, which is our last court of appeal here in Australia, recently heard an appeal relating to a patent application for an electronic gaming machine. And as is pretty standard, the Patent Office had rejected the application, and it had gone through the federal court, which is the court that hears most of our patent cases. The issue before the High Court is, what is the right test for assessing whether an invention implemented on a computer can actually be characterised as a patentable invention at all, or is it merely an abstract idea? The Patent Office basically says it's an abstract idea, reliably almost says it's an abstract idea. In this case, the federal court at first instance disagreed, and then it went to the full federal court, which held that there was no patentable invention because there was no advance in the computer technology itself. It's just doing something better with a computer.
Right.
And that seems to be a very standard approach here. So it's actually the arguments have been heard. So what do I think the High Court will do? I think you'd have to say on the record, on the past record, it's not looking particularly good. Our courts have tended to not uphold the patentability of computer implemented inventions. So it might be the case that we remain out of step with the US and Europe in that regard.
But if you were Chief Justice Sarah Matheson, what would you do?
Well, I think I would. If I had the scope to do it in the right case, I think it would be really good to, I guess, for the court to actually acknowledge that implemented inventions are very much computer implemented inventions are very much part of our landscape. And if we're not going to extend our IP laws to cover that, then we're potentially going to stifle a lot of innovation because people won't invest the time. And I guess that leads on to another sort of really vexed issue here, which I think remains a vexed issue in other jurisdictions as well, which is whether patent protection should be granted for AI-generated inventions. So last year it was really exciting because on a test case that Allens ran, Australia became the first country to judicially rule in favour of AI inventorship. So our federal court found that an AI system can be named as an inventor on a patent application, possibly assisted by the fact that our Patents Act here, unlike some overseas, doesn't define the term inventor. So the court basically said, well, the ordinary meaning of inventor is not limited to humans, and there's no specific provision in the Act that says that an AI system can't be invented by a non-human inventor.
Right.
So that was great. Much fanfare, many articles written, the hoping of a chink in the armour. But then our full federal court weighed in and overturned that decision.
Yes, I recall.
So that means that we're now aligned. in a good way or not, with the UK and the US and Europe, which have so far invented AI inventorship.
Do you find that the courts in Australia are open to argument that, like you were saying, well, if we don't extend protection to such and such, we're going to have some severe economic problems from the cascading effect of people not innovating and economic impact, or are they not really into these meta policy issues?
I think, strictly speaking, they try to keep that sort of that separate. But this is actually a really good example of this case where the judge gave some policy suggestions, if you like. So perhaps less than your US Supreme Court, which I don't know whether they admit it or not, but seem to actively engage in policy setting. Here, that our courts are pretty careful, I guess, to keep that separation. But in this case, the full federal court, while rejecting that our current, they took a different view as to whether our Patent Act actually would permit a construction that says that an inventor doesn't have to be human. So while they rejected that non-human inventor concept under our current law, they did actually suggest that as a matter of policy and as a matter of some urgency, which is unusual, that lawmakers should be looking to whether AI inventorship should be recognised in Australia. So where do I think that will go? I think there's a sufficient groundswell of interest and commercial imperative that the government will probably do a consultation on AI and IP. And I know that the UK IP office has recently done that. So I expect we'll follow suit here.
That's fascinating. But speaking of policy, and I know that you've been very involved in the AIPPI and all those kinds of things. So maybe you could speak a little bit about your involvement there. And one of the things I've noticed is that ambitious lawyers from jurisdictions that are not densely populated with lots and lots of legal work, say like the United States, tend to become heavily involved in these kinds of transnational organizations, which I think is a great thing. I'm just sort of curious about your thoughts about what you've done there and your thoughts about joining those kinds of associations and the opportunities they may have in general.
Well, I think IP has always had a much more international flavour to it than a lot of other areas of law, partly because there's IP law is heavily influenced by international IP treaties.
Right.
And I guess the nature of IP means that while you can have a system governing it that's confined to a particular country, as with the rise of global companies, they want to sell their products and their services, and those products and services don't necessarily have international boundaries. If there's a market, they want to be able to pursue it. So I think IP law has always had sort of a more international flavour than perhaps some other areas. I was really lucky that the head of our IP group when I was a junior and mid-level lawyer was himself very involved with international IP organisations, and indeed all of the partners in the IP group from day one would have, according to their area of IP practice, we tended sort of to divide it up so that different groups within the IP group would look after or become very involved in a particular international IP association, whether that be trademarks, predominantly with INTA, or AIPPI was seen as a bit more patent oriented in those days. I think that AIPPI has never actually been purely about patents, but that tended to be one that we that the patent litigators gravitated to. So I was very much encouraged to get involved from an early stage, but also not just to be a member, but to actually sort of roll up my sleeves and get actively involved in the work. And AIPPI is very much sort of a working international association, in as much as the sort of one of its key activities is really to look at the current state of IP law around the world and form a view as to whether that represents best practice and whether harmonisation of IP laws around the world would actually make the IP system better for the users of the system.
Right. No, it's fascinating.
Yeah.
No, I didn't mean to cut you off. Sorry.
Yeah. So basically, but as you've mentioned, from a less densely populated sort of IP world, it's a fantastic opportunity, because if I'm, as a mid-level lawyer, if I'm going to be advising clients with global operations who might be running patent cases in multiple countries at the same time, while the work that I did with AIPPI is never going to, well, it doesn't mean I'm going to be qualified to advise in other jurisdictions, but you get a really good understanding of those things that we were talking about earlier, sort of what's the same, what's different, the subtle nuances.
And you also meet referral partners, because I think that's how I met you. I think it was through a number of AIPPI colleagues of yours that I engage in other jurisdictions.
Absolutely, and that of course is one of the reasons that law firms are prepared to spend the money sending their lawyers overseas. But yes, I keenly remember, David. I think the first meeting that we had in that litigation, where we were all getting together.
Oh, in London.
Sitting around the table in London, I was thinking, I don't think there is a single colleague, person here who's not an AIPPI colleague, which is, I guess a reflection of the fact that it's got a very wide membership, and that I guess we've worked together on IP policy and advocating for better IP systems. So we actually know how each other works, and I think that's also really helpful for having a very integrated team when you're.
No, definitely. I think that's 1,000% correct. One of the sad things in the U.S. legal market is that they pay associates so much money, which is not a bad thing necessarily, but they don't let them train and don't let them spend time. Like when I was a junior associate, we had time to do those kinds of sort of bar associations. Now it's really not very common, and a lot of lawyers don't feel the need because they're very parochial in the States. But I think it really does a lot of training and working together with people from different backgrounds and stuff like that. I think it's wonderful.
Mm.
But I think the reason why it was around the table that way in London at that big meeting was because it was mostly non-U.S. lawyers, and it was people that I knew who introduced me to people that they knew, and it was just sort of a cascading effect like that, and it was a great experience. So, but moving along, so now that we've sort of given the highlights of legal stuff, you're no longer, is it fair to say, you're no longer a practicing lawyer?
Yeah, that is a fair summation. So after 28 years of amazing law firm practice, and 26 of those as an IP lawyer, I left what I still firmly believe is the best IP practice in Australia, and that wasn't because I'd fallen out of love with law or fallen out of love with IP. I do actually remain passionately interested in innovation and how we protect it and how we make the best use of it. But I guess having gone through multiple long lockdowns in one of the most locked down cities in the world of Melbourne, actually gave me some time to remember what I'd originally thought when I started legal practice, which is that I would do other things beyond private legal practice. The issue was that I'd actually loved it way more than I thought I was going to love it, right. And so try it out for a while and see what happens next. Turned into a very long career. So even though it had exceeded all of my somewhat naive and fairly and early graduate expectations, I also knew that I'd probably have regrets if I didn't mix it up a bit and do some other things. So the issue was, of course, being a busy IP lawyer in private practice. I didn't really have time to ponder what that might actually look like, let alone
Right.
develop and implement a plan. And frankly, if the next 20 years go as quickly as the last 26 have done, then I'll basically I'd run out of time. So I basically decided that I'd like to, I guess, explore the world that I'd always had as part of what I had found to be a very fulfilling career, which was to be on boards of various organisations. So essentially, since I became a partner, I've always been on one or other or multiple boards. You mentioned AIPPI, where I served for a number of years, and eventually becoming the Reporter General. But I also was on various boards in Australia around legal reform, access to justice, social justice, legal education, and also elite vocational artistic training. And that's really what has, I guess, sort of been bringing me back to the full circle. So some years ago, I was contacted by a friend who was on the board of the Australian Ballet School, saying, we've got this incredible health team who are really looking after dancer health, and one of the teachers turns out to be an inventor, and a bit like what you described earlier on, David. They kind of, lots of people invent things, and they always want to test out is this going to be how they're going to make their millions?
Right.
Suffice to say that the arts in Australia does not receive nearly enough government funding, and so the prospect that this teacher might have invented something patentable was quite exciting, and I was asked to give some advice about that. So it turned out she invented lots of things, and we talked about lots of things that I would have found incredibly useful when I was a ballet dancer, I have to say. Unfortunately, none of them were patentable, but at a point in time when they were looking to have some more corporate board members, they approached me and asked me to join the board. So that was a very exciting thing for me, and I've been on that board for quite a long time, possibly longer than one should really be on a board, but I just love it so much, and I'm currently the chair.
Oh, wow. So what do you do as the chair of the board?
We, as I said, we're very much a working board. It's in the not-for-profit world, you tend to populate the board table with resources that you don't necessarily have in the organisation.
Yeah.
And then I became chair not long before COVID struck, and that has it's been a challenging few years. If you can't have students in the studio, you can't really charge them fees to the same extent that you could if they were training on 5-6 days a week. We have a boarding house for international and overseas students, and again,
no one could come in and out of Australia for a while.
Being in the most locked down city in a fairly locked down country, that presented some challenges. But I guess with challenges come opportunities. It meant that we had I had at least as many discussions with government as I did as an IP lawyer, but very much around funding gaps and applying for government assistance. Rather than suggesting that IP laws needed to be changed. But that's, we're slowly recovering from the effects of that. And there's the future is very bright. I think we've recently just come back from a tour in Sydney of a new ballet. And
do you get to go with all the tours and stuff?
Yeah, and the reviews were fantastic. So, and our students are just so pleased to be back on the stage where they belong.
That's so fun.
Yeah, but I was going to say, so having had that fun experience, and having been on sort of, I guess, more boards related more to my sort of professional life, I think where I've landed is that I would like to do more of that, not necessarily limited to IP, but I guess in relation to companies where they are, putting a high value on pushing the boundaries and developing new things, and using the innovation assets of the company to create value. And one area that I have done a lot of work over the years is sort of in the healthcare sector, whether that be for large pharmaceutical companies, or companies making medical devices. So with more of an engineering bent to it.
Right.
It was, again, when I was approached to join the board of the Royal Melbourne Hospital Neuroscience Foundation, which effectively is the conduit for most neuroscience research, early stage medical research in Australia. That was a really good opportunity to, again, sort of be involved in an area in a subject matter that I find endlessly fascinating. I mean, at the end of the day, what could be more fascinating than the human brain?
Yeah. No. Wow. Wow. You seem to. I am envious of where you ended up. It sounded like it's very exciting.
Yeah,
and fun.
Yeah, and over time, I'd like to, perhaps at another couple of boards, and in fact, I have literally last week I've gone back to school, so I'm doing
Oh wow.
to directors school. So the Australian Institute of Company Directors runs a course which everybody assured me that just because I'm a lawyer who's been on boards, I shouldn't assume that I would know it all, and I'm certainly finding that really, really interesting and challenging.
No, having served on a company board, there's a lot of public company board in the States from Baringo. It's there's a lot of things that have to get done that you may know the laws,
Yeah,
but you don't know how to do it.
yeah, exactly right. And you by being on boards, you sort of pick it up organically.
Right.
But I thought that, well, if this is really the direction that I want to take, then I really should go back to first
Well,
principles.
yeah, organically will depend on also who your mentors are. That you may get the wrong advice, unfortunately.
Absolutely.
Wonderful.
Yeah.
Well, listen, Sarah, I really, really appreciate all this time that you've given us. You've had a fascinating career, and it looks like you have a very, very fascinating second career lined up. And I really thank you for your time. And wonderful, did great. And how do people get in touch with you who want to speak to you about anything Australia or anything on the boards, or what's the best way?
Well, I guess the best way is probably just through my LinkedIn. LinkedIn is the one form of social media that I am somewhat reliable about. So LinkedIn is probably the best starting point, and obviously I've the great benefit of having the IP career that I've had is that I've got so many IP friends around the world, you included, and I'm very, very keen to remain in touch with everybody.
No, definitely stay in touch, and if I ever can make it down to Australia now that things have cleared up, I'd love to actually see you in your native habitat.
And we'll actually let you in, so that's great.
Anyway, well, thank you very much, and it's been great chatting.
Thanks a lot, David. Lovely to chat to you too.